Hello everyone, my name is Lalit Soni and you are watching Polity This Week by Drishti IAS. In this episode, we will be discussing some of the important political developments which has happened in the last week and that can be important for our examination. So let's start our discussion. Today we will be discussing nearly 6 articles or 6 topics in our discussion, and that can be related to your syllabus and that will be important for your examination. Okay, so let's start our discussion. Here we will be talking about the right to overcome the caste barriers. Okay, so here there was this one case, that is Sukanya Shanta versus Union of India. In this particular case, Supreme Court has made some kind of observations that with respect to the prison modules, okay, with respect to the prison modules, whatever discriminatory elements are there, whatever discriminatory provisions are there, that has to be revived. So Supreme Court has told the central government that within 3 months you have to actually take care of this particular issue, and recently the center has come up with some of the draft. Okay, they have tried to change these prison modules. Okay, so in that regard we will be talking about the right to overcome the caste barriers in the prison as well. Okay, then coming to the next one, national mourning. When we are talking about the state funeral and the national mourning, etc., which has recently came up in the news after the demise of our former Prime Minister, that is Manmohan Singh ji. Okay, so with respect to that, we will be talking about some of the provisions and what happens in this area. Okay, then coming to the next one, conjugal rights for prisoners or the conjugal rights of prisoners. Okay, now when we are talking about the inmates or when we are talking about the jails, there are some of the, you can say, states which are having some kind of conjugal rights which has been given. Some provisions are there. Recently in Delhi is considering to go through the conjugal rights again. So in that regard, the conjugal rights were in news, so we'll be talking about some of the provisions. We will also see outside India what kind of provisions are there. Okay, then assisted dying and the debate around it. Recently in United Kingdom, they have come up with a bill in the parliament. Okay, that bill is with respect to the assisted dying. Okay, now we will not go into the provisions of that bill, but we will be talking about the concept. We will be talking about the concept of euthanasia. We will be seeing that in India what are the laws, or in India what is the procedure. Also we will be talking about the some of the Supreme Court's judgment which was there in this regard. Okay, then private members bill. Recently there was this article in the Hindu. That article said that when we are talking about the altogether the discussions in the parliament in 2024, only 9 hours or 9 point some hours has been, you can say around 9 hours has been spent on the private members bill. That means that only few bills has been taken up for the discussions, or you can say only few bills has been tabled in the parliament by the private members. Now we will be seeing that why this private members bill are significant, because most of the time you will be seeing that private member is a member who is not part of the government. Okay, now if he is not part of the government, that means that he is the member of parliament and he is in the opposition. So opposition can raise some of the issue in the form of the private members bill, though the chances of getting it passed is very rare, but again discussion will be there in the parliament. Okay, so we will be talking about that. Cruelty as a ground for divorce. Recently Supreme Court has made an observation, and again they have said that when we are talking about the cruelty, there are certain aspects of which be it your physical cruelty, other than that the mental and the emotional well-being will also be considered over here. So mental cruelty or the torture will also be considered as cruelty as a ground for divorce. Okay, so we will be talking about this as well. Okay, now before moving further, I would like to tell you that we are offering ISGS foundation courses offline batches at our Noida sector 15th center. When we are talking about the address, this is given over here, C171/2 block A sector 15 Noida. For the English medium, date is 9th of January, 6 p.m. time is there, and when we are talking about the Hindi medium, the date is 16th of January, 11:30 a.m. time. We will be starting our batch from this particular day. If you want any kind of information, you can call on this number, that is 87501 87501. Again, number is 87501 87501. Okay, or you can directly visit the center. I have already told you the address. Nearest metro station is Noida sector 15, so you can directly visit and get enrolled. Okay, now let's come up with the practice question which was given to you in the previous lecture. We will be talking about that questions and then we will be starting our discussion. Okay, who can remove a governor from the office? If you have attempted it already, well and good. If you have not, you can answer right now in the comment box. Okay, who can remove a governor from the office? President of India, the chief minister of the state, prime minister of India, or the state legislature. So option A is your right answer, because governors work on the pleasure of president. Okay, so that is one thing. Second question is there, Who appoints the chairperson of the National Human Rights Commission in India? Recently, it has been done by the President of India. So, option A would be your right answer over here. Though that works on the advice of a committee which is of 6 members. So, we have already discussed that in the previous lecture. Coming to the next one, what is the primary objective of declaring a region as a protocol area? Protected area. I'm sorry. Region as a protected area. Okay. To promote economic development, to prevent foreigners from accessing sensitive or the strategic areas, to establish large-scale industrial zones, to enhance local governance and the infrastructure. So, option B is your right answer, because recently we have seen that in some of the northeastern region, this regime has been again imposed, okay, throughout the area of the state. Okay, so option B would be your right answer. Now, coming to the first discussion over here, right to overcome the caste barriers. Now, right now, when we are talking about, or the before, some months ago, till then there are some of the works which are been allotted in the prisons on the basis of the caste. Okay, so let's say if this is some work is there for the cleaning, so there was a particular caste which to whom they will be assigning that particular work. Now, in the prison modules also, there are certain terminologies or the certain communities were referred as the, let's say, habitual offenders or the criminal tribes, or other than that also there are some of the, you can say, derogatory words, you can say, which has been used in the criminal when we are talking about the prison modules. Other than that, there was this provisions that wherein the work used to be assigned on the basis of the caste. Now, that has been challenged in the court under the Sukanya Shanta versus Union of India. In that case, Supreme Court has given these guidelines that this particular kind of discrimination is basically against the Article 15 of the Constitution. It is against Article 21, that is right to life with dignity. That is against Article 23, which is against the exploitation. So, these were the arguments, or these were the observations which has been made by the Supreme Court, and Supreme Court has also directed that the central government and the respective states shall go for corrections in the prison modules within 3 months. Central government has done that and they have come up with the new ones. So, now we will be talking about the issue over here. Okay. Now, what used to happen? Right to overcome the caste barrier, Sukanya Shanta versus Union of India and others. The Supreme Court has set aside the caste-based discriminatory provisions of the prison modules or the manuals of several states, which provided for the allotment of work based on the caste of the prisoners and their segregation. So that was the issue which has been taken up by the Supreme Court, and they have made sure that is unconstitutional. Okay, the court declared that these provisions are unconstitutional and ordered the state and union territories to revise their prison manuals within 3 months. Okay, so that was the observation which was made by the court over here. Now, if you look at the judgment, there are certain things they have actually explained or they have used over here which can be important. Let's say some of the articles has been mentioned. So let's see. Supreme Court has held the caste-based discrimination in Indian prison is unconstitutional and violative of Article 15. Article 15 of the Constitution says that state cannot discriminate on the basis of religion, race, caste, sex, etc., etc. So here there is one term which is there, that is caste. Now, only on the basis of caste you cannot go for any kind of discrimination. Okay, so that is there in Article 15. Then coming to the next one, the court emphasized that Article 21 also includes the right to overcome the caste barriers. Now, when we are talking about the Article 21, Article 21 is basically your right to life. And right to life and the personal liberty, when we are talking about, that is right to life with dignity. Okay, so here when we are talking about the dignity, that means that these kind of caste barriers should also be overcome. Okay, then coming to the next one here, Article 23 clause 1 provides an enforceable fundamental right against the social and economic exploitation. So they are saying that that is against the Article 23, that is against the exploitation as well. Okay, here that can be social as well as the economic exploitation. Here there are 3 articles which becomes important for you, so you have to remember these articles. Now, Supreme Court has condemned the prison manuals for using the terms like scavenger class, criminal tribes and habitual offenders, and enforced caste-based segregation for cooking and you can say cleaning. So basically they have condemned it, and they have said that assigning tasks based on caste, like choosing sweepers from a specific caste, is now illegal. So that has been discussed in the Sukanya Shanta versus Union of India case, which we have discussed right now. So basically there are 3 important articles which are there, that is Article 21, Article 15 and Article 23, which becomes important for you. And other than that, you know that now such provisions has been removed from the prison manuals. Okay, Now let's move further to the next one, that is basically talking about the state funeral and the national mourning. Now recently we have lost our one of the eminent personality, that is former Prime Minister Manmohan Singh ji. Okay, now he was a very learned person, and other than that also his contribution to our country was significant when we talk about our economic reforms or the LPG reforms, etc. Other than that, the banking reforms, he has performed really well. So considering that also, and other than that also, various awards has been given. So considering the contribution, we have gone for the state funeral and the, you can say, national mourning. Now let's see what is that. State funeral, a formal and the ceremonial funeral for prominent individuals such as president, prime minister, former president and the governor. For them it is fixed that for president, prime minister, former presidents and the governor it will be there. Other than that, if there are other personalities for which government wants to do it, so central government may approve it. Okay, so that is on the that can be the prerogative of the central government, which will be deciding on that. It will be organized by the Ministry of Defense upon a notification from the Ministry of Home Affairs. Now Ministry of Home Affairs will give you the instructions. On the instruction, it will be arranged by the Ministry of Defense. Why? Because you will be seeing that there will be gun salutes, there will be military bands which will be performing over here. So that is why it will be, you can say, organized from the Ministry of Defense. Then gazetted officers and the military personnel in formal attire must attend it, and then open to the public participation. Public can also be participating over there. Now if we are talking about the protocol elements, here body will be wrapped in the tricolor or the national flag. Military bands performs morning tones over there, and the gun salutes will be performed. Okay, so this is the state funeral. Now state mourning, if we talk about, or the national mourning if we talk about, that is to collectively honor the deceased and their contribution to the nation. 1 to 7 days can be declared by the center or the state government. Okay, both earlier only central government has the power, but now state government can also do that. Okay, so that is there. Protocol if we talk about, so national flag will be flown at the half mast. Now when we are talking about the state mourning or the national mourning, you will be seeing that our national flag will be hoisted at the half mast. Okay, then coming to the next one, formal and the cultural programs will be suspended. Then public holidays is optional. In case of you can say president and prime ministers, that public holiday will be there, but otherwise it is optional. State can announce it or not, that is up to states. Okay, so that is there. Now what is the procedure, or what are the rules with respect to the national flag and the half mast rules? Okay, so here you can say it is the what is the significance of national flag half hoisting at the half mast. That is basically to give the kind of respect to the deceased person. Okay, a mark of respect during the national or the state mourning. Now if we are talking about the procedure, so first the flag will be hoisted to its full height. Okay, it will be hoisted to the full height, and then it will be lowered to the half mast. Okay, then not lowered on the Independence Day, Republic Day and the Gandhi Jayanti. If these 3 days are there, then it will not be lowered to the half. Or when we are talking about you can say only the building which is having the body, which is housing the body, only at that particular building the flag will be half mast. Then coming to the next one, special instructions if we are talking about, so for leaders or the military personnel, the saffron side of the flag must be towards the head. Okay, and if we are talking about the common citizens, so that is not allowed for the common citizen. That is kind of a violation of National Honor Act 1971. Okay, so that is about your state funeral and the national mourning. And when national mourning is there, then what will be doing, that is the national flag will be hoisted at the half mast. Then we have talked about that. Now we will be talking about the third topic over here, that is assisted dying and the debate around it. As I told you, recently in UK they have come up with the you can say bill over there. Other than that also, there are the various countries which are there for the suicide tourism. This term has been in the news recently when we are talking about the Sweden, etc. So these countries are there in which assisted suicides are allowed. Okay, so considering that this particular topic has been a topic of discussion, or it has been in the public discourse, so we will be talking about that. Okay, now first you have to understand that what is assisted dying, what is assisted suicide, what is euthanasia. Okay, so let's see what is the difference. So assisted dying generally refers to a person who is terminally ill, receives lethal drugs from a medical practitioners, they themselves administer the drug. Okay, so what is happening over here, one important factor is that the person is terminally ill, one thing. Second thing is the lethal drug will be administered from the medical practitioner. so that medical practitioner himself will be administrating the drug. Okay, so that is assisted dying. One important condition here is that the person is terminally ill. Coming to the second one, assisted suicide. Now this is intentionally you are helping someone, intentionally you are helping another person to end their life, including someone who is not terminally ill. Here they are saying that if someone is willing to die, okay, if someone is there and he wants to die but he is not terminally ill, in that case if you are assisting them to die, that is basically, you can say, that is assisted suicide. Now there are some kind of machines or the, you can say, boxes which has been made, okay, which are you can say suicide bots they are considered as. So what will happen is that you will have to go and sit inside it, the box will be closed, and under that some kind of gas will be released, and slowly you will be dying inside the box. Okay, so that is your, you can say, assisted suicide. Here it is not necessary that you are terminally ill. Okay, now there are certain countries which are providing these services, and because of which there is this term which is called as the suicide tourism. Okay, that is into discourse. Then coming to the next one, that is euthanasia. Euthanasia is an act of deliberately ending a person's life to relieve suffering, in which a lethal drug is administered by the physician or doctor. Now here you can say, here objective is to, you can say, end the suffering of that particular person. Okay, so that is there in euthanasia. Patient may or may not be terminally ill. Now if there is a person who is at the vegetative state, okay, now in that case you can go for the euthanasia. Now depends what kind of euthanasia you are, considering. There is the active euthanasia, there is passive euthanasia, there is voluntary euthanasia, there is non-voluntary euthanasia. All these things are there. Let's talk about that. Patient may or may not be terminally ill, which we have already discussed. There are two type of euthanasia which is there. One is voluntary euthanasia, wherein the person has given the consent. Now by the way of a living will, or by expressing it somehow, the patient has given, or the person has given the consent that they want to die. Okay, so that is the voluntary one. Then there is this non-voluntary, wherein the person cannot give the consent because they are in the vegetative state or they are in the coma. Okay, that is basically non-voluntary euthanasia. Now coming to the other part or other type of euthanasia, that is active euthanasia and the passive euthanasia. In active euthanasia, what is happening is that you are giving a lethal drug. You are giving a drug to end the life. In the passive euthanasia, what you are doing is you are removing the life support only. You are not giving any kind of drug for them to kill, but just that you are removing the life support, and the person will be dying as natural death, because obviously without life support he cannot survive. Okay, so these are the two different kind of euthanasia which is there. An active intervention to end the person's life with a substance or the external force, like by lethal injection. Okay, then coming to the passive euthanasia, withdrawing the essential life support or treatment, keeping a terminally ill person alive. Okay, so if there is a particular treatment which is basically keeping a person alive, and you are removing that treatment, or you are stopping that treatment, or you are taking away the life support, in that case it will be considered as the passive euthanasia. Okay, I hope that is clear. Now coming to the next part, what are the, you can say, cases which has been decided by the Supreme Court or the courts with respect to the euthanasia in India. So there was this first case, that is P. Rathinam versus Union of India. Now in this case there was this one section of IPC, that is 309, that was penalty for the attempt to suicide. Now that has been challenged, and court has said that this section should not be there. So they basically kind of challenge the constitutional validity of the section 309, that is penalty for attempt to suicide. Now in the second case, that is Srimati Gyan Kaur versus the state of Punjab, in that case they have overturned the earlier judgment. In the earlier judgment they have said that yes, the person can try to can go for the suicide, and there will not be punishment for that. Okay, for the you can say, if they are going for the attempt to suicide, there will not be a punishment. Then in the Gyan Kaur they have actually overturned it, and they have said that right to die is not under right to life. Okay, so it is not under right to life. Now there is one difference, that right to die with dignity, it is under you can say right to life. Okay, when we are talking about right to life, you know that right to life with dignity is the, a right which is there. Similarly, there is a right to die with dignity is also a fundamental right, but right to die is not. Okay, so they have said that in this particular judgment, in the Srimati Gyan Kaur versus State of Punjab, they have said that right to die is not there under Article 21. That is not covered under Article 21. So here you can see Supreme Court overturned 1994 judgment and held that right to life, Article 21, did not include right to die, which must not be mistaken with right to life, right to die with dignity. Okay, so that is the differentiation which has been made in the Srimati Gyan Kaur case. Then comes the Aruna Shanbag case. Aruna Shanbag case, which was there in 2011, that has been decided, wherein the concept of passive euthanasia was accepted in India. They have said that in the terminally ill or in the exceptional cases, we can go for the passive euthanasia. Here you can see Supreme Court allowed passive euthanasia for Aruna Shanbag and made a distinction between the active and the passive euthanasia and allowed the latter in certain situations. Okay. Then comes the another case, that is Common Cause versus Union of India. Here comes the concept of living will. When we have discussed that there should be a consent, okay, voluntary consent, non-voluntary consent. So that considering that, when we are talking about this consent part over here, voluntary euthanasia and non-voluntary, wherein we have talked about the consent. Okay, so when we are talking about this consent part, that has been introduced here with the concept of living will. A person can administer their own will, and they can decide that if there is a vegetative state, if I am terminally ill, what can be done. Okay, so here Supreme Court legalized passive euthanasia, claiming it as contingent upon the person having a living will. Okay, if a person does not have a living will, in that case his or her family members can make a plea before the High Court to seek the permission for passive euthanasia. Now if person has the living will, he has already decided that this is how I would like to die, that is fine. If they have not, there is no living will, in that case the person's relatives can go to the High Court, and then High Court can decide on the matter. Okay, so that is the laws which are there with respect to the passive euthanasia in India. So in India we allow passive euthanasia, we have the concept of living will, but we do not allow active euthanasia. Okay, so that is about this thing. Now laws in India which we have already discussed over here. You can see that the Supreme Court has recognized in the Common Cause versus Union of India 2018, Supreme Court ruled that the right to die with dignity is part of the fundamental right to life under Article 21. Now again they have said that right to die with dignity is there. Okay, so that is the differentiation which has been made over here. The legality of the passive euthanasia was established, allowing withdrawal of the life support for terminally ill patient or those in permanent vegetative state. That is what the passive euthanasia is, and which is allowed in India. Passive euthanasia enables natural death without medical intervention, differing from the assisted dying. In the assisted dying, what you are doing is you are basically giving a lethal drug to kill someone. Okay, you are intervening, or the medical practitioner is basically intervening over here. In passive euthanasia, you are just withdrawing the life support. Okay, so that is about laws with respect to euthanasia in India. We have talked about the assisted dying. All these aspects we have covered. Now coming to the next one, conjugal rights for the prisoners. Now conjugal rights means that when we are talking about the reproduction or when we are talking about the intimate movements, okay, so do the prisoner have such rights or not? Okay, so that has been talked about in this particular article. So basically what will happen is that if the inmates or the prisoners are being given some time off, they are being sent on the parole, or if there is some kind of arrangement which is there in the prison itself. Okay, so these are called as the conjugal rights with respect to the prisoners. Okay, so let's see over here. The Delhi government is reconsidering a proposal to allow conjugal visits for the prisoners. Okay, now here when we are talking about the conjugal visits, here you can see the private family visit where inmates spend time including the intimate moments with their legal spouse within the prison. Okay, one thing which is important, that is legal spouse, and the thing is you can say these inmates are there in the prison, they can enjoy the intimate moments, that is the conjugal visits, okay, which are there. It promotes inmates rehabilitation and the long-term recovery, enhancing the psychological well-being and sustaining marital ties of the prisoners. Okay, so that after some time, if they are going outside, let's say there is a person A. Okay, Mr. A has been accused of something and he has been sent to a jail for, let's say, 20 years. Okay, he is married. Now he has been jailed for, let's say, 20 years just after the marriage, let's say within 1 month after the marriage. Okay, and he is a person of, let's say, at the age of some 30 he has got married. Okay, at the age of 30 he has got married and he has been sent to jail, and he will be coming outside after 50 years. Okay, so at the age of 50 years, he will be coming outside. Now there are chances that he might not be able to go for, you can say, conceiving a child, because obviously, there is this biological limitations are there. Okay, now considering that his life can be hindered. Okay, now all these things, or you can say there is this right to reproduction, right to procreation, which is there. Considering that, there are these conjugal visits which has been their provisions has been made. Okay, now let's talk about these judicial landmarks with respect to that. Here you can say Punjab and Haryana High Court in 2014 upheld the right to procreation or the reproduction for the prisoners. Madras High Court in 2018 allowed parole for the conjugal relations. Parole is a, you can say, temporary release from the, you can say, prisons, so that they can go for the conjugal relations. Okay, so there are some precedences which are there, and now Delhi is also considering such things, so they will be reconsidering the proposals. Okay, now other countries, if we are talking about, so there is provisions of the conjugal visits which are there in some of the United States. Okay, which is there, and in the federal prison it is not there till now. Okay, so in United States, you know that there are states prisons which are there, and then there is a federal prison which is there. So in federal prison it is not allowed, in the state prison it is. Then coming to the next one, in Europe, countries like Spain, France, Sweden and the Denmark permits such visits, with Spain offering monthly and the Sweden offering 9-hour sessions. Okay, so these are some of the aspects related to the conjugal rights and the conjugal rights for the prisoners. Okay, if they ask about India, so in different states there are different kind of precedents which are there. So that is about your conjugal rights of prisoners. Now, cruelty as a ground for divorce. Recently, Supreme Court has discussed it, and in that case, they have discussed the Section 13 of the Hindu Marriage Act. And in the Section 13, there are various grounds on which you can seek divorce. Okay, and in that, one ground is cruelty. Now they have discussed on the definition of the cruelty, so we will be seeing that as well. Okay, so here you can see Hindu Marriage Act is a statute which is basically talking about the marriages. They are talking about the marriage related concerns, divorce, you can say other conjugal rights, etc. Okay, so Hindu Marriage Act is a law in India which governs the marriages among Hindus, Buddhists, Jain and Sikhs. It provides rules and regulation for the solemnizing and registering the marriages. The act specifies conditions for the valid marriage, rights, obligations of spouses and the ground for divorce. Now here in the Section 13 is there in the Hindu Marriage Act. There are some of the grounds which are given. Okay, fault based grounds. If there is one ground is adultery, then cruelty is also one of the ground. Desertion, conversion into another, you can say, religion. Then unsoundness of mind, leprosy and venereal diseases and renunciation and presumption of death. So these are some of the ground. You can go through the you can say description which is given over here. It is easy to understand. Now one of the ground is cruelty, on which we will be talking about right now. Now, when we are talking about the definition of the cruelty, here you can say that cruelty as a ground has been added in 1976 amendment. Okay, now when we are talking about the definition, so here broadly it has been said that generally we will be considering the physical cruelty. Okay, someone is assaulting you or hitting you, that is considered as cruelty. But the court has said that the physical as well as the mental cruelty will also be considered. Okay, the act of violence or the bodily harm, that is considered under the physical cruelty, and the behavior causing emotional or the psychological distress, that is under the mental cruelty. Okay, now determination is left to the judicial discretion on the basis of the facts and the circumstances of the cases. The judiciary will decide whether cruelty was there or not. Okay, the definition of cruelty, it includes mental pain and the suffering that makes living together impossible. It is beyond physical, it goes beyond the physical violence to include the sustainable or the sustained emotional suffering. Okay, so basically the idea here is that along with the physical one, even if there is a mental torture or any kind of you can say mental cruelty is there, that will also be considered under the definition of the cruelty, which can be a ground for divorce. Okay, now here if we are talking about the legal understanding of cruelty in marriage, so that judiciary is deciding on certain factors. Okay, one of them is the importance of the mutual trust. They will be seeing that between the spouses there, if there is this mutual trust or not, which is necessary. If there is no mutual trust, you cannot stay with someone in a marriage. Okay, that is one thing. Second is irretrievable breakdown. If the marriage has gone beyond repair kind of condition. Okay, so if there is a breakdown which cannot be repaired, okay, so that in that case also you will be considering that as the ground. Then patterns of behavior. Here they will be seeing that deliberate or the persistent action, not only the physical harm. If there is a person who is trying to go for the some kind of manipulation or for a over the longer period of time, that will also be considered as the behavioral pattern, and that will also be considered for the deciding whether it was cruelty or not. Okay, so that has been discussed in the case by the Supreme Court. In simple words, you can say that there is the sections 13 clause 1a, wherein they have actually section 13 clause 1 subclause 1a. Okay, so in here they have discussed the cruelty as a ground of divorce, wherein they have included physical as well as the mental cruelty. Okay, I hope that is clear. Now, private members bill, this is the last topic for today's discussion. Now, recently it was seen that very few time has been given for the discussions, that is nearly in the whole session in 2024 they have only given 9 hours for the discussions with respect to the private members bill. Now, that is the kind of, you can say, that effectiveness is decreasing, or the kind of discussions in the parliament, the nature and the quality of the discussions is being deteriorating. Okay, so that is what has been in the news, and considering that, we will be talking about the private members bill. Now, any member of parliament who is not a minister is referred as the private member. If any member of the parliament which is not a minister is considered as the private member. Now, the private members can also come up with their own bill and they can present in front of the parliament. Okay, so the purpose of the private member bill is to draw the government's attention to the issues in question and gaps in the existing legal framework. If there is a legal framework which is not talking about certain aspects, certain issues, so to address that particular gap, they can come up with the private members bill, and government is not taking care of it, or government is moving away from that particular issue, so you can bring your own bill in the parliament. Okay, so that is there to draw the government's attention to the issues in question and the gaps in the existing legal framework which require legislative interventions. Okay, now it reflects the stand of the opposition party on the public matters, because obviously opposition party does not has the number, so obviously when they are coming up with the private member bill, there are high chances that they will not be able to pass it. Okay, but because they have tabled a bill, there will be a discussion in the parliament. When there is a discussion, the views of both ruling party as well as the opposition will be talked about in the parliament. Okay, so that is there. The drafting of this particular bill is the responsibility of the member who has actually come up with the idea. Okay, so it is the responsibility of the member concerned. Its introduction in the house require a 1 month notice. You have to give the 1 month notice. Private members bill can introduce and discussed only on Fridays. Okay, so that is one thing, very important aspect here, that 1 month notice is required and it can only be introduced on Fridays. Okay, introduced and discussed on the Friday. Its rejection by the House has no implications on the parliamentary confidence, because obviously it is a private member bill. It has nothing to do with the government. Okay, so this is about the private members bill, some of the facts we have discussed over here. Now, for you, there is a small test wherein you will be attempting this question and answer to me in the comment box. Who can declare state mourning? Parliament, Prime Minister, President, state government, or the central government? Okay. Which landmark case in India established the legal framework for passive euthanasia? Keshwanand Bharti versus State of Kerala, Aruna Shanbag versus Union of India, Vishakha versus State of Rajasthan, Olga Tellis versus Bombay Municipal Corporation. Okay. Then coming to the next one. Under which section of the Hindu Marriage Act 1955 is cruelty recognized as the ground for divorce? Section 9, Section 10, Section 13, 1, subclause 1a, and Section 24. So you can attempt this and answer to me. And then the question is, under which section of the Hindu Marriage Act 1955? We have already seen that, sorry. Okay. On which day are private members bill typically discussed in the Indian Parliament? Monday, Wednesday, Friday, and Saturday. So you can attempt all these questions and answer to me in the comment box. With that, I would like to take your leave. If you have not subscribed the channel, please subscribe it. Have a nice day. Thank you. I'll see you in the next episode.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.